mass murderer from Skagit County wants to withdraw his guilty pleas.
He's been locked up for a decade, but now says he only pleaded guilty to avoid the death penalty. And now that the death penalty is considered unconstitutional in the state, he wants a redo. You probably remember the chilling case. Isaac Zamora went on a shooting rampage back in 2008, killing 6 people, including a Skagit County Sheriff's deputy. Now, Simone Del Rosario has been looking into this and the legal motion all day. So what can you tell us?
Well, there's a potential here that this could just open up Pandora's box for all of these cases where people pleaded guilty to avoid the death penalty. In Isaac Zamora's case, this is a man who is clearly mentally ill. He had multiple diagnoses of schizophrenia. He claimed he thought he was shooting demons that day. Of course, none of that takes away from the destruction of lives that he caused around his hometown of Alger back in 2008. 6 people dead, 2 others shot. He committed these crimes and he was facing 20 charges. The death penalty was an option. And in a plea agreement, the state agreed not to seek the death penalty if he pleaded to the following: not guilty by reason of insanity for 2 counts of murder, guilty for the other 4 counts of murder, guilty for 6 counts of attempted murder, and guilty for 8 other charges. Now, in a motion filed earlier this month, his attorney argued it is fundamentally unfair that because of the threat of the death penalty, which is unconstitutional, Mr. Zamora gave up his right to a jury trial where he could have presented a well-supported insanity or diminished capacity defense. Now, I reached out to the Skagit County Public Defender, Wesley Richards. He told me he can't comment on pending litigation. So I reached out to another criminal expert, attorney John Henry Brown, who famously defended Ted Bundy. He told me this argument has legs, but it could also open the floodgates.
I think there'd be a great incentive for the courts to sidestep this issue one way or another. And there's a number of ways they could do that. But it's not a frivolous argument, and the courts need to weigh in on it, that's for sure.
Now remember, last year was just when the state Supreme Court ruled that the death penalty was unconstitutional. Brown tells me it's pretty predictable that we would eventually see a case challenging this now.
You know, in all the stipulations I've read where they plead guilty, they write out a statement saying they're pleading guilty, but I don't recall any of them saying, well, I'm doing it to avoid this, or because my mom asked me, or because whatever. They just say, I'm guilty, I did it, I confessed it. But I don't recall it ever saying something like, well, I'm trying to avoid the death penalty, right? That just seems like they're doing the carrot and the stick a little bit. It just doesn't seem like a sound legal argument to me anyway. But I've seen courts do things I don't agree with sometimes, particularly in this state. What happens if the court does decide that there are some legal grounds to let this proceed?
I will say first, I read some of Zamora's writings from prison. He did say that he was afraid he was going to be executed if he didn't make this plea agreement, and that's why he went forward with it. He never thought that he'd be released from the mental hospital. That being said, if he withdraws these pleas, it's because he likely wants to plead insanity for all of his crimes. But Brown tells me that juries rarely buy this insanity defense. Take a listen.
If they reverse his guilty plea, the remedy would be most likely go back to trial. From the evidence that I know in Mr. Zamora's case, he would be convicted. So he would be then sentenced, most likely, to life in prison without parole. And I think that's the most likely outcome. So the question is, why go through all that? And why put the victims through all that again?
It would obviously be a very painful situation for this community to have to go through this again. He's been convicted for 10 years now. He started his sentence at Western State Hospital. He was moved to prison, is now at Moreau Correctional Facility. The hospital had called him an escape risk, a threat to his staff. That's what moved him into prison. Again, this case has the potential to set a precedent here. Brown doesn't think this is the case to do it. He says that there is a small percentage of people that are serving life in prison right now who are actually innocent. The statistics stand behind what he says. He thinks one of those cases is more likely to set a precedent than this one.